The next case is State versus Samamra, is that how we say his name?
I pronounce it Samamra, Your Honor.
Samamra, okay.
Yes, sir.
Each part of that 15 minutes presents argument. Counsel, you may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
2 minutes, Your
All
Honor.
right, very good. The arguments are being recorded, so when you're up there speaking, number one, stay behind the podium because if you move, we lose you from the video. Secondly, please speak up loud enough so we can hear you, so the video can pick you up and introduce yourself when you come to the podium.
Thank you, Judge.
When you're making your argument, please, if you're referring to any victims or any minors or children, please refer them by initials or some other term, the victim or the accuser or something, so we know what you're referring to, or who you're referring to, I should say.
Yes.
So without name, that is it. We've read your brief and are ready to proceed whenever you want.
Thank you, Judge. May it please the court, Joseph Pagano on behalf of Mr. Alaa Samamra. I filed an appellant's brief on behalf of Mr. Samamra, and as I previously stated, I would reserve 2 minutes for rebuttal time. Mr. Samamra was indicted on a 6-count indictment that had to do with what he believed was consensual sexual activity with the accuser. The case proceeded to trial. He was found not guilty of counts 1 and 2, but subsequently convicted by the jury in counts 3, 4, 5, and 6. The judge sentenced him to 1 year on each count concurrent. He was granted an appellate bond and is currently proceeding forward with his appeal. Now, I filed the appellant's brief. I cited 5 assignments of error. The first 2 are sufficiency and manifest weight. The third had to do with allowing the witness to testify remotely, and the objection that was placed on the record by the defense. The fourth had to do with an abuse of discretion in excluding the CCDFS records, and the fifth had to do with the separation of witness violation that took place during the trial. I'd like to focus on the first 2 issues if I could today. In this, those 4 counts are sexual battery, substantial impairment sexual battery, and then unlawful sexual conduct with a minor. Now, for the sexual battery count, the state would have to prove that the victim or accuser was substantially impaired and that the defendant reasonably believed that the accuser was substantially impaired. My position is that the state failed to present evidence of either. I think that this court has dealt with the voluntary intoxication to qualify substantial impairment in State v. Hansing, and they said that a minimal statement, or you've said, this court has said that a minimal statement that a person was intoxicated standing alone would not be sufficient to demonstrate sufficient or substantial impairment absent other indicia, and that's what I think we have here. We have a statement by the accuser that she was drinking. That statement is not backed up by anybody else who testified.
Well, what about the one that testified that said that she had to help her to the toilet, that she was so intoxicated she couldn't even get on the toilet alone, and basically put her in a bathtub?
Well, I do remember that, Your Honor. Other than that, and I apologize, other than that statement, there's nothing to kind of corroborate the position that she was intoxicated. The officer who responded indicated that he thought she was intoxicated, but he didn't think she was impaired. And the other testimony throughout the entire trial was that she was texting with friends, voice texting. That friend, I believe that was GM, said that she sounded the way she always does on the text. She was laughing on the text. The accuser herself said that she knew what was going on, that she just let it happen, that she never said no, she never tried to push him away. And then it comes into kind of the context of the party as a whole, Your Honor. It was a graduation party. My client had never met this young lady. He assumed that everybody there was graduating from high school, so being either 17 or 18 years old. There was a question or not a question, but there was testimony about how she was dressed, piercings, makeup, high heels, not dressed like a person of the age that she was.
And the victim here was 13, right?
Pardon me?
The victim was 13.
Yes, Judge, that's correct.
There were photographs of her that evening that were introduced as evidence. Is those the photographs that were introduced, are they specifically of the evening in question?
Yes, those, I believe, are the exhibits that are in the file. Now, I was limited somewhat in what I was able to look at. I mean, I know that the judge did make the order and sent the CCDFS records over. I was unable to look at any of those. But there were photos in the file, and there were text messages or Instagram messages showing about what the types of things she was saying, how she was behaving. And there was a number of other things that there was, it was found she was looking at pornography. She initially disputed that, said she wasn't, but then when she found out that the officer in question had screenshotted it, she came clean and admitted that. So I think it is.
Did she admit she discussed that pornography with the defendant in this case?
Did she discuss it with him?
Right.
I don't recall that. The conversations that I recall that they had, Your Honor, had to do with him being an immigrant from Palestine and that, discussing food, those types of things. So she was engaging in conversation with him. My client did not know, had no reasonable belief that she was under 17 or 18 years old. He would never have guessed that she was only 13.
Well, this was a party where high school people were at. I mean, I take all the young people there were high school age. This wasn't a college graduation party. Is that fair?
Yes, sir, that's correct. That's correct.
Is your view, it's safe to assume without further question that everyone at a high school party is at least 17 or 18?
Every party's different. I would say there are parties where there are kids there that are younger, certainly. But that comes from, our background of having grown up in this country, attended those parties, seen what was going on. My client's an immigrant, and he was at his girlfriend's house, and he was of the belief that everybody who was coming to that party was similar to his girlfriend's daughter who was graduating from high school or about to graduate and was going to be in that 17 to 18-year-old range.
Did I make a mistake when I was reading? I thought he was actually, had become a citizen.
He is a citizen, yes.
Okay, so he'd been here for a while.
He'd been here for, I think he became a citizen when he was 17.
I'm not sure
He's
that's
25
relevant with
now.
anything anyway, but
He's been here for a little bit, yes.
okay. And I also am not sure I understand the relevancy of the fact that she was looking at pornography. What's the purpose of introducing that even?
Well, I think it kind of goes to her credibility. She denied it, so it was introduced because she was not telling the truth about what was going on that evening.
Well, somebody asked the question to begin with, though, about the pornography, and that's how she denied it.
Right, I understand that. From my perspective, that's where it comes in. If there are no further questions, I will rest on my brief and my response brief.
Well, I will ask you, and you covered some in your reply brief, but as far as assignment error number 3, explain again what clear evidence is that there was an objection by your defendant below about proceeding on to it.
He put an objection on the record at the very beginning when the witness was being called, and the whole idea of her testifying by Zoom. And it's my position that he didn't waive that. I mean, it's a tough position to be in as defense counsel when something like that is going on, because we're standing in front of a jury, and to continually lodge objections and have them denied, you can't do that because you lose credibility in front of the jury. Defense counsel, the trial counsel, and I've spoke to them dozens of times over the course of this appellate process, put that objection on the record and never withdrew it. once that objection is there, it stands firm. And the client has an absolute right under the Constitution to confront a witness, especially somebody who gets on the stand and says something as damning as effectually she was a little kid, she's a child, that type of thing. And that's the last thing the jury hears. I mean, it's incredibly damning. And it is wholly different to deal with somebody via TV screen than it is in the courtroom. And I think that the Supreme Court is pretty clear on this. She was not, this witness was not unable to attend. She was just on vacation. So I don't think that there was a real reason for her to actually appear by Zoom, or a good reason.
So the objection was when this witness took the stand, your client objected below on and through counsel. I object to this proceeding on Zoom, meant the confrontation clause, but then once the witness started to testify, did not object further. Is that fair?
I think that's probably accurate, yes. From my recollection of the transcript, Your Honor, but I don't think he has to have continue to stand up and object. That's my point. I mean, it's very hard. You know, the prosecutor represents the state of Ohio. They come in the courtroom. They're looked at one way by jurors, and defense counsel's looked at another. And you have to be very cognizant and careful about how you try the case, because not only is your client being judged, you're being judged. And so to continually object and have objections denied is very damaging, I believe, to your presentation to the jury. So I don't think they withdrew the objection. I think it was a solid objection. And with that, I'll rest. Thank you, Judge.
And you'll have your full time for rebuttal.
Yes.
Good morning, Your Honors. Again, Mark Coase on behalf of the State of Ohio, Lorain County Prosecutor's Office. With regards to assignment of error 3, I would still argue in my brief that there was a motion to eliminate filed that morning, and there was an objection where they did state we are preserving this for the record. But when it came time for Lindsay Everling to testify, there was no objection. Additionally, if this court...
Well, and I haven't had a chance to review the record, so let me understand, if I can, what occurred. So when this witness went to testify, did defense counsel stand up and said, again, I'm objecting, I'm in front of I'm objecting to her testifying by way of Zoom in this case?
Not at the time when it came for her to start testifying. The weekend before, during the weekend, I believe the state filed a motion to have her testify via Zoom. The defense filed an objection, and then there was a brief hearing on it before the trial started. After that, there was no, Your Honor, we are objecting to this testimony going forward.
And the trial court had ruled on it and said they're going to allow the
They
testimony.
were going to allow it based on the, at the time, the state making representations that she would be a material witness.
And that's on the record, the discussion pre-trial is on the record?
Yes.
Okay.
I would argue that if this court were to find that it was properly preserved, ultimately looking at this court as they decided in Stefanko and Carter that recently came out from the Ohio Supreme Court, this testimony, if it was preserved, was ultimately harmless. Lindsay Everling did not testify to the state of the victim, did not testify towards her age, if she appeared intoxicated. Any statement she tried to get in, specifically where the victim shouted, "He raped me," was objected, was not let in. Ultimately, defense counsel, based on the way the questioning went, didn't even cross-examine her when they had the opportunity to. So ultimately, I believe that if you were to strip away her testimony, it was harmless.
So why was she a material witness?
I think initially trial counsel thought he was going to get in more statements out of her, specifically towards the state of she was in at the time, how she appeared. Unfortunately, due to technology, the judge getting frustrated with the Zoom, lagging, it's obviously we're not reading, you're reading it, but you can see the judge saying stop, there's a delay, we have to hear what she has to say, or we have to respond to this objection. Looking towards assignment of errors 1, 2, and specifically assignment of error 1 on the issue of sufficiency of evidence, this court enhancing looked at the definition of substantial impairment, found that it's not defined by the statute. It is a tough thing to point to. Voluntary intoxication could cause substantial impairment, but not just because you consume alcohol, that does not mean it leads to substantial impairment. I think given the court relying on, I believe it was Daniels, saying that it must be established by demonstrating a present reduction, diminution, or decrease in the victim's ability to either appraise the nature of his conduct or to control his conduct. And this is distinguishable from the general deficit in the ability to cope. I would argue that based on MY's testimony with regards to sexual battery, substantial impairment, she testified that she drank 2 White Claws, she felt tipsy, and then later Mr. Samamra provided her 5 to 6 drinks of alcohol. He would later say he didn't give her any alcohol. But as she testified that she couldn't understand what was going on, particularly she was too scared. I was in the room alone because he left me there to make sure no one was around. I was too drunk to really do anything. You know, you really don't know how to react, especially when you're intoxicated. Additionally, Gabriella, who the birthday party, the graduation party was for, said that she had to help her get her to the toilet, and ultimately Sergeant Alton, who was an officer, arrived, said she did appear intoxicated. But we did provide more than enough evidence with that. With regards to the unlawful sexual conduct with a minor, we would argue that he was reckless in regards to knowing her age. That was the basis they went forward on. Recklessness has been defined as a heedless indifference to consequences. I'd say it was definitely at a party where he knew that were people supposed to be age under. He would later say he thought they were all 17 or 18. He made no attempts to know who he was. He was purposely putting her in a separate room away from his girlfriend that was sleeping next to him. Even the judge on the Rule 29 motion, looking at the photo of her that night, could determine that a reasonable jury could conclude that she was 13 years old in that photo. Looking towards manifest weight, and I think enhancing overturned sexual battery conviction on that. And I think, and as I put in my brief, I think one of the most important differences between enhancing and here is enhancing. You had the video of her at the bar reaching over, drinking, and then you have the video afterwards. You don't have the actual assault, but I think the ninth as the panel, that panel was able to actually sit there as the 13th juror and really look at that evidence of her behavior. This is so factually distinguishable given that that was an employee, they were both legal age drinking. But here, there is no video, there's only the testimony. So based on that, I mean, the jurors did find her to be credible. There was some issues of, they said she's not credible, and ultimately it was up to the jury to believe her on that. I don't think there's enough, I think there's enough evidence on both sides, and I don't think there's enough to overturn the jury's position on that.
In this case, there's, as I understand, at least texts that were sent by her around the time of the incident. And I don't know if there were TikToks or Instagrams or what were sent. Are there any live videos that were admitted of her during this time?
No, what was admitted was there was text, and then there were audio texts that I think were ultimately admitted. The TikToks are the social posts that ultimately were limited of her.
They were the next day.
Those are the defense's proffered exhibits, which they're in the record. I would agree with that the trial court did not abuse its discretion when it limited that, especially looking at evidence rule 611. The one exhibit, I think it was defense proffered exhibit E, was the woke up naked next to someone. Ultimately, questioning her about that, I think that did go towards rape shields. It's her sexual conduct, not at this time, there's no date, we don't know when that was from. Based on that, I'd ask you to overrule. Thank you very much for your time.
No rebuttal, Your Honor.
The court will take the matter under advisement and issue a decision in due course. The clerk will mail a copy of that decision to you upon its release. It will also be available on the High Supreme Court. With that, I'd like to thank both of you for your presentation.